Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Syuhairah Binti Yusoff 1171859. Today I will present about the position of fatwa in the Syariah Court, the case of legalization of illegitimate child. Okay, the first one is we go to the abstract. An illegitimate child is a person who has been born to a parent outside wedlock as the result of shubha consummation. Research on illegitimate children has become the focus of public attention either from the point of view of fiqh or law, and discussions on illegitimate children are also considered necessary. This issue creates conflict between the religious institutions in Malaysia, such as the Fatwa institution, in determining the status of illegitimate children, consisting of various opinions. Thus, this article aims to discuss the usage of fatwa relating an illegitimate child and the position of fatwa about these issues in the Syariah Court in Malaysia. Thus, this article aims to discuss the usage of fatwa relating to an illegitimate child and the position of fatwa about these issues in the Syariah Court in Malaysia. This article seeks to recommend improvement concerning the position of fatwa and the opinion of the Mufti as one of the authoritative sources of law in the Syariah justice system in Malaysia. This may contribute to the effort towards reducing the problem of illegitimate children in the society. Okay, the first one is introduction. Illegitimate child is a child born out of the wedlock to adultery or rape, and he or she is not from the shubha intercourse and not out of slavery. In Malaysia, a fatwa is recognized as one of the sources of Islamic law to resolve particular disputes and legal issues. In some situations and cases, a fatwa is needed and become a reference in the Syariah Court. Nevertheless, the position of fatwa about this issue resulted to different judgment between the Syariah courts in Malaysia. Okay, there are two fatwa regarding the nasab of a child birth in Malaysia. The first fatwa allows a nasab to a child after the birth is 6 months and 2 lahzah, which is 2 seconds from the date of marriage. And the second fatwa is admit the nasab to a child even the birth less than 6 months with certain conditions. Okay, the objective of this research is to identify the position of fatwa in the Syariah Court. Second is to examine the usage of fatwa relating to illegitimate child in Syariah Court in Malaysia. And the third one is to analyze the cases relating to illegitimate child in Malaysia. Okay, the method that I use for this research is a library-based method, which is analyze documents consisting of reported cases and the relevant fatwas, and then I also use a relevant thesis, journal articles, and newspaper cutting about illegitimate child and fatwa. Okay, so we move to the result of this research. Okay, there are statistics of pregnant adolescents or pregnant teens in Malaysia, which is shows that the red line shows that married women pregnant. The statistics of married women pregnant, and the blue line shows that the statistic of non-married women pregnant, which is non-married women pregnant. So, based on the statistics in 2017 shows that the totally cases, which is 3,694 cases per year, on average 300 cases per month and 10 cases per day. So this statistic shows that the increasing of illegitimate illegitimate birth prove that Malaysia is experiencing a very serious moral crisis and needs to be addressed immediately. Okay, second is the table of the fatwa on nasab of the states in Malaysia. There are 2 fatwa stated. Okay, the first fatwa is from the Wilayah Persekutuan Selangor, Negeri Sembilan, Pulau Pinang, Terengganu, Kelantan, Melaka, Sarawak and Kedah. This stated state that all children born after 6 months and to lahzah, second, from the date of marriage can be nasab to their mother's husband, which is to their biological father, and except the state of Perlis, state that allow a nasab even the birth is less than 6 months and to lahzah from the date of marriage on a condition that the father does not deny his association with the child. We move to the cases. There are 2 decided case. The first decided case is decided case with a binding fatwa, and the second is decided case without a binding fatwa. Okay, for the first one is case Muhammad Faizul bin Zainal versus Syuhairah binti Yusoff 2014. On these cases, the plaintiff and defendant applied to the court to claim that determine the lineage of the child can be decided as a legitimate child and can be attributed to the plaintiff as a father. Judge Kamarul Azmi Ismail rejected the plaintiff claims for the child lineage conviction as valid because the period of birth after the marriage contract was less than 6 months and to lahzah and could not be attributed to the father. So for these cases, the judge used Terengganu State Fatwa and the decision of Muzakarah Fatwa Committee MKI as a reference and authority, stating that a child born less than 6 months is an illegitimate child and cannot be named to a biological father. So, the second cases is the cases of Zafran Zulhilmi bin Fauzi versus Nur Aini binti Nasrun 2013. These cases is the plaintiff made an application to register a child born less than 6 months to lahzah after the date of the marriage contract. In this case, the judge Hamidi Shafi'i ruled that the plaintiff could and should be considered the legitimate father of the child, but if the plaintiff dies, the child can inherit the plaintiff inheritance. So, for these cases, the judge make the judgment based on their ijtihad without referring to the fatwa, without referring to any gazetted fatwa or non-gazetted fatwa. Okay, so based on the case that makes the fatwa as a reference in Syariah Court, proof that the fatwa is an important source of law for the judge in the Syariah Court. Then, for the case of not making fatwa as an authority in the judgment in the Syariah Court, several possibilities can be assumed by the judge does not refer to the fatwa, whether the fatwa from the national level or state level. The conclusion for this research is our findings suggest new act is needed to bind the fatwa in the Syariah Court relating to an illegitimate child. This is because to give legal authority to fatwa gazetted at the state level and to ensure that this issue are decided properly following our state in Malaysia. Okay, for the reference of this research, I use from Statistik Remaja Hamil Sinar Harian for March 2019 and also Muhammad Kamil bin Mat Saleh and all 2019, the position of fatwa and mufti opinion as authority in Malaysia Syariah Court. Received from Journal of Contemporary Islamic Law, Volume 1. Okay, that's all from me. Assalamualaikum warahmatullahi wabarakatuh. Thank you.